Hello, everybody. Hello, Joey Bag of Donuts and Mrs. Donuts. I hope you guys have a wonderful weekend together. Hello, Nana Laura and Nana Laura's mom and dad. I hope you guys have a great night and Nana Laura's mom feel better soon. Hello, C-Rex. Yeah, it's okay. It's okay. As Will Smith says, we can make it if we try. And then there's a K-John Boom. Hello, K-John Boom. Maybe I should tell Mortimer Duke that there's going to be some Judge Ricky tonight. And then he will magically appear. Hello, Lisette Panette. How you doing, sweetie? Hey. I bet you're making all kinds of noise on that microphone over there. Yeah, you cute little kitten, you. Yeah, all they could hear was the rustling of the bag. They couldn't see what kitten was behind it. And of course it's Bandit. Of course it's Bandit. There you go, Bandit. There you go, baby. Hi, Ava, honey. Hello, isn't that special? We're that good. Hello, Eileen Carlin. It is Ava, hiding underneath the kitty fluff. As soon as the kitty fluff gets out of the way, you'll be able to see Ava getting her treats. Tonight, we're going to do superfood chicken breast bites and beef liver treats, both from Badlands Ranch, both from C-Rex. I told y'all if I said Judge Ricky was going to be on tonight, Mortimer Duke would appear. And what do we have here? Hello, Mortimer Duke. Oh, I'm getting kitty kisses. She was giving me kisses on my hand. Okay, I'm trying. She really does love these. Yeah. What's that? That one's the liver. And then this is the chicken. Ooh, yum, 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 yum. I have not tried rehydrating them. They do say to keep water nearby and accessible if you're not going to rehydrate them. But I have not attempted that yet. What's up, baby? What's up? They're gone so fast. You ate them already. I mean, that was real quick. That was really, really quick. And she's like, I know. Okay, so you get a couple of health bars, and then you get a hug, because isn't that special? It's specifically asking for me to give you a hug. Right, come on up. Come on, you gotta get that hug. Isn't that special? And apparently, there's a gift for Billy. I don't know what this is. I had no part in this. Other than, having someone go retrieve it from the front. That's all the part that I add. was saying, hey, there's a package on my front. Can you please get it and bring it inside for me? And the person was like, yeah, I can do that. So that's as much input as I've had in this. And then I texted with C-Rex, and she took the blame for it. Said that this was her doing. She sounded pretty excited about it. She wanted me to open it last night, but I was not well and I couldn't come on. Apparently, it is to stop Billy from running out of the house. So, I'm going to find out. I know, she's used to everything being for her. I know. I don't even know what it is yet. It's wrapped. See, the kitties are just happy to have the box. See, this is all the present that I need. That's all I need to give them right there. See, Earl's happy. He's probably gonna meow here in a minute. All right. We've got a pretty little bag. He's got a pretty little boat. Let's see what we got here. There. I'm struggling. And we got more wrapping. It's okay. Oh, neat. It is a P44 Smart Pet Toy. So it's got 3 projection areas, and it will play laser light with them. That is so cool. Unpredictable trajectory. 10 minutes of automatic operation every 2 hours. This thing's just going to go? What are you? Oh, get out of there. Hey, no. Get Ava. Ava, no. Move it. I did not put that down there for you to... No. That is the cat food. Get. My goodness. Can't hide nothing from you. I just wanted it out of the visual of the stream. Didn't want her to have it. That was not the plan. I know, I'm not mad. I'm too happy to get a little toy here that I'm not mad. It's rechargeable. Okay, so it says press the button. First, M1 projection area is the blue light. Second is the purple light. And third is the yellow light. Fourth is the power off and light off. Twist the button, adjust the speed. Laser light flashes when adjusted to the fastest or slowest. Twist 360 degrees from slowest to fastest. This sounds rather complicated. Not really. But how long do I have to charge it for? That's my question. The last laser toy that they received has ceased to function. Like, I can charge it all day long and then plug it in unplug it and turn it on for the cats, and it's like 5 minutes, it's done. So that one has not been powered for a very long time. So yeah, I'm going to plug this in to charge it. Supports plugging in to work. Yeah, I get that. And the indicator light is underneath, showing which setting you have it on. It doesn't say how long to charge it before you turn it on, but suggest placing it on a table or bookshelf with a height of 60 to 90 centimeters. The higher the placement, the farther the projection distance. And avoid looking directly at it. Interesting. All right, so we're going to charge this up. And then when it gets some go-go juice, we'll make it go-go. Unplug my diabetes monitor. That was dead. Hopefully it's got some charge now. Take my blood sugar again sometime. Someday, maybe. All right, and we have progressed from the micro USBs all the way to the C's. Yeah. All right, here we go. Give that a little juice here. There we go. It's charging. It's red, so I'm assuming that means it doesn't have any charge right now to play with. So we will put that. We'll put a pin in it. Put a pin in it. Go gadget. Yeah, I don't know how well that's gonna work because he really likes being outside. Oh, the one that's right there, that is Earl. Yeah. And he's trying to see if Bandit's under the bed, but Bandit's up here because he likes to attack Bandit. But I did spray. I sprayed all along the side of the bed and some underneath it where Bandit hides. I sprayed it with this Feel Away Classic. It's a pheromone. It's the same pheromone that I have in these little balls that are diffusers. So they plug in, and unfortunately the diffuser doesn't work unless it's plugged in because it has to heat it up and all that fun stuff. But you plug it in and then it just emits calming pheromones for your cats and makes them stop attacking each other. And I'd like to say that part was true. In addition to them, I'm also using Jackson Galaxy's Bully Solution and the Peacemaker and the Self-Esteem. Now, I am still having to break up cat battles, but I do believe that's because Tiny Kitten is not yet spayed. Tuesday, Tiny Kitten gets spayed. And I think all of these behavior issues that I'm dealing with the boys, I think they're going to subside once Tiny Kitten is spayed. Because I think the only reason that I'm having so many problems with them is because they smell all of the kitty hormones on Tiny Kitten, but not on Bandit. So they think Bandit's broken. That's my best guess. It's the only reason I can think of that they would just continuously attack Bandit and nobody else. So, I think that's more a message for us. They get to fend for themselves. Maybe the lasers don't affect them the same that they do us. I don't know. Maybe they might. I don't know. I'm sure there's been studies to that. That's Earl. That's Earl. Yes. There's the vet that I take all of the animals to. They have towels sprayed with Feel Away. And when you get there with your cats, you're supposed to put a towel over their carrier to help calm them. Tiny Kitten's not till Tuesday. Ava is. Ava just got fixed. Bandit's fixed. So Bandit doesn't have the hormones. Tiny Kitten does. Oh no. Well, I'm having like some luck. The aggression's definitely reduced. It's not gone, but it is reduced. Yeah. Earl has always loved to play in his litter box. And the second, like, I can be in the process of scooping the litter and he'll jump in it to use it. Like, it never fails. If I want Earl to come to me, all I have to do is scoop a litter box. He is very, that's a sign of like, dominance, territorial dominance. So, the more instantaneously the cat uses the litter box after you scoop it, it determines like how prone they are to dominance of their space. And Earl is like that. He's in there while I'm scooping. I've been broken for 42 years. Well, he can be my crabby old coot just like you. Oh my gosh. Earl has to like dig his way to the bottom. He has to get all the way to the bottom, and in the process, he has to fling it out. Any excrement that's already in there, be damned. It just all the way out. Onto the floor, onto the carpet. In any species. So we're going to go all over the country again. Kansas, Michigan. I think, did I put Georgia in there? I might have. I don't know. I went around the block. He's a turd hurler. Well, we found that he licks walls, he licks toasters, and he flings turds. He's a special kind of kitty. Yours is the pyramid crafting turd hurdler. Earl is the dig 'em deep kind. I'm so excited about that light. I really am. I'm so excited about this. This is really neat. It's like the perfect size too. Like it's not going to be in the way. And I'm assuming this whole area is, fair game for that laser inside of there, which you can't see because of this black glass over it. But I can definitely see the mechanics inside of there. Ooh, I just dropped my feel away. I didn't hear it hit. It's probably on the floor. Oh, wait. Oh, got it. It landed on my travel pillow. Okay. Sorry, give me just a second here. And then Earl's up in his box now. He's all happy. Gets to be up in his box. I had to have a friend come over and put a capsaicin patch on my neck, but I made them make sure. I fired up the camera and I made to make sure that it wouldn't show up on camera. And now here I am showing all of you. Yeah, it's a Salon Paws capsaicin patch. But my neck muscles were so tight and sore. Oh. Yeah. He's usually not the one that does that. Usually Bandit does, but not the dresser. Bandit does off my desk. Like, she's currently like cuddled like very tightly in between my Leonard Nimoy pick and a box of something that I have sitting there, and she's just like pushed herself into this little space, and she's all hunkered down, but she's happy. You know, I'm petting her, and like, I know she's trying to minimize her footprint in the world and not be seen because she's got no self-esteem, which is where that other Jackson Galaxy bottle comes in from. And I'm hoping that the pheromones are helping with that. I mean, she is at least coming out more. So I'm trying. I see him. I see him up there. I've got Ava in the bed, licking her wounds. I've got Earl on the dresser, perched. And then I've got Bandit over here. I think Billy might be outside. Billy might have... Oh, no. No, Billy came back. Billy came back inside. Hi, Billy. How you doing, Billy? Grandma Bonnie got you a new toy. Want some treats? You do not look thrilled at treats. What kind of a big fluff butt are you? So unimpressed. I tossed him treats and he doesn't even care. He doesn't even care. Look at him. He's not even moving. That's it. You've loafed too long. Oh, we disturbed the loaf. He's sitting on his eggs. No, he didn't even want to move. He didn't even want to move. All right, guys. Earl is just, I don't know. Earl's kind of scaring me at the moment, man. That stare down he gives me. The whole PAWFURM. They're plotting. They're plotting. I should be scared. I should be. Earl is king of the hill. He's closer to Boomhauer, but you can have that. All right, here we go, guys. It's we got a long one tonight. Like we're gonna be on a couple. Well, that's why I started early, because it's like, I don't know, 2 hours and 15 minutes worth of fun.
Rachel Nicole Mayrand. 23T640488. Where is she? I don't see her here. It says time to pay, please, on the file.
Yeah, I wonder if she went in the hall by mistake.
I just love that. So everybody going to opening day tomorrow can go out in the concourse instead of going into the game. You know what I mean? Buy a hot dog across the street and walk around. Your name?
Rachel Marion.
You got to be kidding.
How are you?
You're coming in a year after the fact and asking for time to
I
pay.
just got the notice on the 25th of March. I said the same thing. I said, where is this coming from? I did my workforce days.
Hang on a sec. You didn't pay your fines.
I wasn't even aware.
Ma'am.
Yes, sir. I am on it now. I apologize.
What do you think I'm thinking?
I thought the same thing.
What do you mean you thought the same thing?
Well, when I finally got a notice a year and a half later.
Ms. May Rand.
Yes, sir.
Who's your probation officer?
Jessica O'Donnell.
Call in Jessica. I want to give you a little analysis here, okay?
Okay.
On February 1 of 24, after you were found guilty at a bench trial, I sentenced you. I ordered you to pay $765, 4 days court work program, gave you credit for one, or you had to serve 90 days if you didn't do the court work or didn't make the payments. Your payments were to be paid at the rate of $25 a week, beginning February 29 of 2024. This is April of 25. Last I looked at a calendar.
Yes.
That means you haven't done anything in over 13 months. I'm going to go back and check out how many times you paid. It looks like on April 3 of 25, today you came in with $50.
Yes. And I have more. Yes.
And now you want to act like this is some surprise out of the sky that you didn't know you owed the court money. You didn't know anything.
Yes, I didn't know.
You
I
did know or
completely-
did not know?
I mean, I know how the court works.
I didn't ask you that. You made it sound like you didn't think you owed and you thought you were done. If I misunderstood, listen, don't interrupt me. If I'm misinterpreting what you said, please, when I'm done talking here, Judge, you misunderstood me.
Yes.
Okay?
Yes, sir.
Fair enough?
Yes.
Now you're going to listen.
Yes.
You come in here and you act like you thought all this was behind you. Ms. Mayrand, I don't know what's going on with you. I really don't. But this was as predictable as the fact that it's going to be less than 138 degrees out today. This was so predictable. I mean, I'd bet my house against this coffee mug that you were going to do this. I don't know why. I don't know why. I really don't. But I don't like hearing these things. Your name?
Just hold on, I'll have operation on.
So I'm a little curious. On April 25th of 24, she was supposed to be here for a show cause. I don't even know why I called you in. I have the answer.
Yeah, I was gonna say, this was a non-probation case, court work program only, and then money. Rachel was in rehab for quite a while during this time frame. I did have proof that she was in rehab. She was in Naomi's nest for quite a while. Once she was released from Naomi's nest, she did contact me right away. She contacted me while she was in there as well. She completed all her days on court work program. It's just the money left that we're working
I
on.
know, but I issued a warrant for her arrest on April 25 of 24 for failure to appear for a show cause that alleged that she didn't appear for her court work program days on March the 23rd and April the 13th of 24. So how'd she, we had
I'm
a,
assuming she came back into.
I don't want you to make
custody
any
after
assumptions though, because I don't know that that's the case.
that.
I never saw anything with her. It looks like is that right, Lisa, that on April, what is going on here? You then came back in front of me on April 30, pled guilty. I said, pay additional costs of $700, $75, 2 additional days court work and pay $35 in court work program fees. 1 day court work because I gave you credit for one served. I'm just curious as to why we didn't show cause her after she blew that off.
Again, she was in custody, she was in jail for quite a long term, and then she was in rehab
On-
after that as
Not on
well.
this case, she wasn't. What case were you in custody on?
For this one, when I was in front of you, you said what day? The 30th of April? I was in custody until September.
Of 24?
Yes,
She had
And
pending
then-
felony charges, Your Honor, at that point.
Shocking.
from,
I'm so shocked. I'm just a little agitated that here she comes in a year later and now she wants time to pay. It'd be like me blowing off my mortgage company for a year and then going in and saying, you know what, give me an extension. I'll pay you. Ms. Mayran,
yes, sir.
I don't know about you. I mean, you're hell bent on destroying your life. I can tell you that. I felt like that before. And I know I would have told you if you didn't have the money to come and talk to me. And if you want to dispute that, I will go ahead and go back and I'll instruct her to go listen to the recording right now. And I'll make a determination as to whether or not I adequately explained that. I know I would have told you because I tell everybody. You never asked me for extensions. Now you come in after we're almost done with probation. There was no probation. Where are you working?
At Koi and at Revive at LA Fitness.
What's Koi?
Koi is the new hibachi restaurant right there at West Road and Grange.
What do you do there?
I'm a server, I'm training to be a server.
Are you off the drugs?
Yes,
You are.
yes,
So if I sent you for a drug test right now, you'd be negative.
absolutely.
I can't believe you didn't come and talk to me. You're gonna set up a payment plan now and you're gonna, but I don't want to hear any more about you thought this all went away. How much can you pay weekly? Where are you living? You living at home with your mother?
Yes, sir.
Okay, so you don't have a lot of bills, right?
No, I do not.
Okay. How much can you pay weekly?
50,
Okay.
25, 50 weekly.
You tell me when you can start. Today's April 3rd. It's a Thursday. Next Friday would be the 11th. You want to start next Friday, the 11th?
We start the 15th.
I'll make it the 18th.
Thank you.
If you don't have the money and you pull this nonsense again, I'm gonna lock you up.
Yes, sir.
If you don't have the money and you need more time, you can extend a courtesy to me. Like I'm just bending over backwards for you right now. You will come into the courthouse on or before the due date 8:30, or you will call the courthouse on or before the due date. And I will go on Zoom with you at 8:30 and I will give you an extension. Do we understand one another?
The due date of, so I understand. When's the due date? 100%, just so I understand.
April 18th, starting April 18th,
Okay.
you are going to pay.
April 18th is a holiday, just so you know.
All right, so you can wait till the 21st on that first payment, but every Friday, I'll tell you what, I'll just make it April 21st.
Okay.
That's a Monday. Every Monday, starting April 21, you come in here with $50. You don't have the money, you gotta come talk to me. You don't do either one of those. I'm glad you're clean if you're clean. I really am. You gotta stay away from that. What was it again, meth?
Yeah, it was all a bunch of,
Yeah, I mean, you can't do that. That's bad, 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 bad. Bad news bears.
very,
You look a lot better.
thank you.
That's good. Good luck.
Thank you.
Take care, Ms. Mayran. Don't miss again. And don't be throwing my name out there. You said you know me. Some police officer told me you said, I know Judge McNally. Judge McNally likes me. You did say that to somebody.
If I did, it was the drugs. I apologize.
I don't like people throwing my name out there. Good luck.
Again, thank you.
Thank you very much. Just go down to.
Brandon Robinson, Brandon Lee Robinson, 24R 244 054. Mr. Robinson, your name?
Brandon Robinson.
Counsel?
Good morning, Judge. Mazengate appearing on behalf of Mr. Robinson.
All right, so this is a telephone harassment that's being pleaded disorderly, right?
Correct, Judge.
Is that what you want to do, Mr. Robinson?
Yes.
If you plead guilty here, the possible penalties are up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yeah.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court or jury, right to question their witnesses, right to testify at a trial or remain silent. If you remain silent, the jury will be instructed that they're not to hold that against you. If you plead guilty, you're giving up your right to a jury trial, your right to a trial of any kind. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt if you plead guilty. Do you understand that?
Yeah.
Any questions on your rights?
No.
To the charged disorderly person, how do you plead?
No contest.
It is no contest, please.
Why is it a no contest plea? Why are we doing a no contest plea? I didn't see anything about a no contest plea, but why a no contest plea?
As far as for civil liability, Judge.
Yeah. What do you do, allegedly? You sending improper text messages? Nah, I'm not taking a no contest plea. It's either gonna have to be a plea of guilt or he's gonna have to go, we'll just have the trial at 1 o'clock.
Can I have a Zoom with him for a few minutes, Judge?
Yeah. There has to, okay. All right, go ahead. I'm gonna put you, we'll let you go talk to him. I'll stay here. We'll go from there, okay? Thanks.
Agent, can you put him in a breakout room?
I don't do that, or Lisa does that.
She's on.
Yeah. Lisa, can you put him in a breakout room to meet with Mazen?
Yep, I'll do it right now.
Okay.
I promise you, this guy does not want to take this to trial.
I'm here on that case.
All right, okay.
So we can get it done.
Is he in here?
Wait, he's coming here.
He's coming.
Bring in Mr. Robinson again, Lisa, please. Recalling Brandon Lee Robinson, 24R244054. Mr. Robinson, your name again?
Brandon Robinson.
Mr. Gave?
Good morning, Judge. Mazengate appearing on behalf of Mr. Robinson.
James Collin on behalf of the city of Rockwood, Your Honor.
So have you had a chance to talk to him further?
We have, Judge. He's agreed to the guilty plea, and I think we've got a city ordinance that would fit the factual basis here.
If you plead guilty to disorderly, the possible penalties again are up to 500 fines, 90 days jail. Costs are all of those. If you plead guilty, you're giving up your right to a jury trial. You're giving up your right to question their witnesses at a trial, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, waiving the presumption of innocence, waiving the requirement that the people show that you're guilty beyond a reasonable doubt. Do you understand that?
Yes.
All right. Do you have any questions on your rights?
No.
To the charge disorderly conduct, how do you plead?
Guilty.
All right. On October 27 of 24, did you have contact with the victim in this case, who is a Laura Weisenstein?
Actually, Your Honor, I think it was Riley Barrios is the actual victim.
Oh, okay.
Lauren is the mother.
Okay, Riley Barrios, did you have contact with her?
Yeah.
All right, and what kind of contact?
Inappropriate language.
Did you text her inappropriate messages, sir?
Yes.
What kind of inappropriate messages?
I just asked her to take some pictures.
I can't hear you.
I said, I asked her to take some pictures. It was nothing specific. I just said, take some pictures.
Well, it says here, correct me if I'm wrong,
Yeah.
Mr. Cullen, does the complaint not allege, let me just double check. I don't want to paraphrase or anything here. Does it not say that he made harassing, obscene, and threatening telephone calls by sending inappropriate text messages? Is that the complaint that was authorized?
Yes.
What were the inappropriate text messages that you sent, sir?
I just asked for some pictures.
Did you threaten?
No, I did not
Any,
threaten her.
did you make any threats? All right.
No.
Your Honor, it falls more under immoral conduct.
What did he do?
Well.
You tell me what you think he did.
He was contacting a 15-year-old girl, asking her to send pictures.
Inappropriate nude
pictures.
photos?
No, it
can't
was not.
specify if they were nude.
Mr. Robinson, hold on.
Mr. Robinson, just be more specific with me, sir.
I am being very specific with you. I stated what I said.
You asked her to send you pictures. Pictures of what? The amount of
Your Honor,
Monte Cristo? What do you mean? You asked her to send your pictures. What was the intent when you asked her to send you pictures?
To send some pictures. That's exactly what I stated to
What
her.
kind of pictures were you referencing?
I never stated nothing specific. I never stated nothing specific. You want me to? I'm not going to lie on myself.
Slow down, Mr. Robinson. Slow down for a second.
You didn't say anything specific because you knew that you're a grown-ass man talking to a 15-year-old, and 15 gets you 20.
Nobody wants you to lie.
Him, possibly get him.
Hang on. If I were him, I'd go down about 3 decibel levels. Okay? You asked her to send you photographs, right? Do you have any of the text messages?
Your Honor, they weren't text messages. They're actually Snapchat. They were conversations through Snapchat, which get deleted afterwards.
They were deleted?
They're deleted upon read. That's how the Snapchat app works.
All right. Okay. I'm glad I don't know a lot about technology, but you asked her to send you photographs. Is that right?
Yes.
Did you specify the type of photograph?
No, I did not.
Did you have anything in mind about what type of photograph that you wanted to receive from her?
Yes.
And what kind of photograph did you want to see from her?
Well, obviously some inappropriate. I never stated nothing, so I'm not gonna say nothing that I didn't say.
That's not what he's asking you, Mr. Robinson. Just
that's what he's saying. I didn't say nothing.
What kind of photographs did you want her to send?
Just some
what kind of photographs did you have in mind?
Some bra and panty shots.
I'm sorry, what did he say?
Bra and panty shots, Judge.
Bra and panty shots. I see. All right. You satisfied, Mr. Gay?
Yes, Judge.
Are you on probation or parole, Mr. Robinson?
No, I'm not. I've been up. I got discharged March 8th.
Anybody forced you to plead guilty?
No.
All right. I'm going to accept your plea to disorderly. I'm going to dismiss the telephone harassment. You got a really bad record here. You know that?
Yeah, that was when I was a kid.
How old are you now?
40.
All right, I'm going to order a pre-sentence report on this. I'm going to dismiss pursuant to the agreement of the parties, the original charge, accept the plea to disorderly. We need a pre-sentence report. All right, sir, you're going to need to come up here today and be interviewed by the probation department.
Yes.
And then we will set a sentence date right now. I would like maybe the mother here of the victim.
For the sentencing?
I think so.
Oh,
I'm troubled
right.
by this. Give me a date, Lisa, please.
That don't even make sense if you just.
Mr. Robinson,
Never mind. Go ahead. I apologize.
It doesn't make any sense to me that somebody be asking a 15-year-old for bra and panty shots, but
I never did.
but
I never did.
hang on. Mr. Robinson, if I were you, I'd take it down now about 6 decibel levels. You seem angry, and with your record, you got no reason to do anything but be very remorseful. You do what you want. But I'm not going to argue with you. You're not going to raise your voice with me, and you're not going to tell me what makes sense or doesn't make sense. I forgot more laws when I was 8 than you'll ever know, okay? So don't start getting smart with me.
Not to mention, this man-child should be grateful that he's getting a disorderly person charge and that he's not actually being charged with something to do with solicitation of a minor or, you know, the harassing and stalking telephone charges that were just dismissed as part of this plea or anything like that. No. Yeah, he is a significant creep. And like I said, you know, the only reason that he didn't say to the girl, please send me bra and panty shots, is because he knew she was 15. But I bet you if we saw those text messages, I bet you he tiptoed all the way around that fine line.
I apologize.
When are we doing the sentencing, Lisa?
April 17th at 8:30.
April 17th at 8:30, you come up here today, you undergo the, and by the way, you said the victim's name is Riley what?
I believe it's Barrios.
That's who I'm adding as a victim here. You cannot have any contact with her or her family members, okay?
I understand.
I should have not said that on here. My mistake. I'll see you guys here on April 17th, and you can come up here now, Mr. Robinson. Thank you. Thanks, Lieutenant. Thank you, Mr. Pelland.
Thank you, Your Honor.
Thank you, Your Honor.
Thanks.
In the matter of People versus Michael Vollmer on 251427, appearances for the record.
Good morning, Your Honor. Hannah Gates on behalf of Mr. Vollmer. We waive the formal reading, enter plea of not guilty, referral to OAC.
Court will enter plea of not guilty, office of assigned counsel. Pre-exam conference is April 10th at 8:30. Preliminary exam is April 17th at 1:30. That's in front of Judge Jurens. As to bond.
As to bond, Mr. Vollmer is a lifelong resident of Saginaw, 39 years. He has gainful employment and does construction. He has nothing pending, was forthcoming about his prior criminal record. He's not on probation or parole. We're asking the court for a reasonable bond or a PR bond in this matter.
Based on the nature of the charges, based on the fact that the prior record that the defendant has is older, is gainfully employed, will he have no contact with his roommate or former roommate?
Yeah, I believe that roommate moved out, Your Honor.
Right. The bond will be converted to personal recognizance, no contact with the victim. My, also, he is to have no firearms. Any firearms are to be surrendered to the police, or if there's an alternative, that's make other arrangements and notify the court what those are. So no firearms, no legal controlled substances, no alcohol. All right.
No, that's all right. Victim just came in. That's why. Right?
Jail, is Mr. Vollmer still available?
He's already brought up to this floor.
That's all right. Here's what I'm gonna do. It's my understanding, it's come to my attention that Mr. Vollmer has had contact with the victim from jail. So I'm going to, in accordance with the court rule, confirm that, but right now I'm going to hold off on issuing a bond. And if that's correct, then what I'm going to do is change his bond. So he'll be So there's some more restrictions and probably a cash bond of some type. All right, just to let you
Sounds
know.
good, thank you, Your Honor.
People versus McKnight, 25887. Appearances for the record.
Good morning, Your Honor. Hannah Gates on behalf of Mr. McKnight. We waive the formal reading, enter plea of not guilty, referral to OAC.
Court went a plea of not guilty, office of assigned counsel. Pre-exam conference is 4/10 at 8:40. Preliminary exam is April 17 at 2 p.m. That's in front of Judge Jurens. As to bond.
Esteban, Mr. McKnight has lived in Saginaw for his whole life of 20 years. He is currently unemployed at the moment. He has nothing pending, but he is on probation. He just spoke with his probation officer yesterday. We're asking the court for a reasonable bond or a PR bond in this matter.
You look like you should be either getting ready for a college class or getting ready to go to work or something productive, not being in jail. What the hell? Man, what you're charged with?
And why I said college, maybe you could be in an engineering class.
Right.
To take some skill to take a Glock 9mm and bear it into a machine gun switch.
Did you hear what he did? He took a Glock 9mm and made it into a machine gun switch? What?
As it's alleged. Then they have fentanyl, as it's alleged.
Oh, you were born in 2004. Who does Mr. McKnight live with?
I'm not sure.
My mother.
Your mother know where you're at right now?
Yes, sir.
You were drug tested today. How would you test?
Clean. I'm subscribed to Suboxone. I go to Hope Urgent Care, and I got a weed card. I do smoke marijuana.
Well, that ain't gonna happen. Who issued you your weed card? Call it.
The Michigan. It's in my wallet. It's like Green Light Wellness. I'm pretty sure.
When's the last time you've been to your own doctor?
My own, like from like a clinic.
Like from either Great Lake Bay or Main Street or Dr. So-and-so at so-and-so road somewhere?
It hasn't been like recent, I'm pretty sure. Only place I go is like to the clinic or to my, yeah, that's about it.
Question I have is how am I going to sure that maybe you might see to another day or another year in your life? You're on a path that's not, well, since I don't have this case, I guess. You're on a path that takes you somewhere where you don't want to be. Community's bad enough now. We need all the help we can get, and you're not making it any easier. I'll take the bond under advisement. You might sit there a minute until you can figure something out that puts it in your little head that you have a life and you have to do something with it and not do what you're doing. So sit tight until I figure out what I'm going to do and I can regain my composure here and craft a bond that's going to be fair and just. All right.
Spoiler alert, the court cuts off before we ever get to hear what the judge's decision on that bond is.
You're all set. Get comfortable. You're going to have to. In the matter of People versus Roberts on file number 251287 and file number 251265. Appearances for the record.
Dan King on behalf of Ms. Roberts, we waive the readings and need to charges. Ask for referral to the Office of Assigned Counsel, and we're ready to respond.
Court winner pleased, if not guilty. Office of Assigned Counsel. Then as to bond.
As to bond judge, Ms. Roberts, she told me that she has no other prior criminal history, and no other pending cases. She is currently receiving treatment for chemo or for cancer. She needs chemo. I don't believe she'd be a flight risk or a danger to the community. We'd ask for a chemo bond tonight.
See, is it my understanding in 2006 you were charged and pled guilty to retail fraud? In 2009, you had you were a minor with a BAC level that you pled guilty to in Huron County. In 2019, is it my understanding that you pled guilty to retail fraud 3rd degree in Huron County with 30 hours of community service, 6 months of probation and fines? And then in 10/31 of 24, you have a charge description of failure to stop at the scene of a property injury accident in Huron County where you were 9 months. Are you on probation?
No, I'm not.
9 months, $760.
They had reduced it all because of the situation that had
Don't
occurred.
care. The fact that you said to your attorney, who was probably the only person that's standing with you, with all 10 million people in the state of Michigan charging you with the crime of stealing and contributing to delinquency of a minor, you weren't forthcoming. So how do I know that you're forthcoming with me? Because anything you say has to be verified. So let me ask you, if you were drug tested today, how would you test?
I don't have anything in me except for what I get from my doctor because I get infusions and chemos. I have my infusion today actually at 1 o'clock and I'm going to an institution on Friday.
Where is
Tomorrow.
this supposed treatment that you received?
I have a port in me, right here.
And
See
where?
At my house.
Where do you
My
go
apartment.
for your
In
treatment?
Bad Axe, in my apartment.
Who is your doctor?
And it's Dr. Stevens in Detroit, a pulmonology. And my nurse comes to my apartment and gives me my infusions and stuff. And
Who do
then
you
I go
reside
to an
with on,
institution.
who do you reside with and the people on Watkins Place?
That's me.
Who else lives there? Just you?
Well, my kids.
Anyone else?
No, Your Honor. And I'm gonna have to look into that court in Huron County because 2 of them were supposed to be expunged.
Is Child Protective Services involved?
No, Your Honor. Be in an institution for a little while because I tried committing suicide after this all happened. Supposed to be scheduled to go tomorrow.
That you appeared voluntarily is the only reason why I'm going to place a PR bond. However, bond will be $7,500 personal recognizance pursuant to court rule. But pursuant to court rule and given the nature of the charges that this case involves retail fraud, also involves the allegation that the children were present and then contributing to the delinquency by encouragement to theft, as are in the allegations. The conditions on bond will be with day reporting. That means that you will also be drug tested today. I'll have you go over to the jail yet this morning to drop. If I know of any substances in your system that are not prescribed, then you'll be released. If I do not know of any substances in your system, you will be held. You clear on that?
Yes, Your Honor. Now, on a daily basis, how am I supposed to contact on a daily
They
basis?
will let you know. It's more to,
Because of the privacy and the Lapeer institution, like, I don't know how I'm gonna do that.
you are going to sign a release that this court has all information. So there is no, you are on bond now. And I'm determining whether or not I'm going to turn this over to Child Protective Services as well.
I didn't know this.
So no illegal controlled substances. You will drop today. No alcohol as well. No other contraband. While you are here on this floor, you'll go over to Office of Assigned Counsel. In addition, once you are finished with Office of Assigned Counsel, you'll then go over to day reporting or pretrial services that is in the basement of this building. From there, you'll be directed to the jail to drop. Do you have any questions?
No.
Very well.
Did you see her lawyer's soul leave his body at one point there? I'm pretty sure I saw that.
Michael
Yes, sir.
Bimbo.
Sir.
Good morning, sir. Looks like you're here this morning charged with fleeing and eluding ×2, aggravated assault with a deadly weapon, driving with license suspended, revoked, habitual, leaving the scene of a crash involving damage to property, carjacking without a firearm, criminal mischief, alter, destroy, conceal physical evidence, obstructing without violence, possession of a controlled substance ×1, 2, 3, and a failure to register a motor vehicle. Do you understand that's the reasons why you're being held this morning, sir?
Yes, I understand some of it, but I don't
They'll
understand.
give you a copy of the affidavit and complaint, Mr. Bimbo, that'll, I know that's a lot, but they'll give it to you there and you'll see exactly what they got you charged with, the specifics. But for purposes of this morning, I did review the affidavit and complaint, and I do find there is probable cause for the charge. I do find that you are entitled to a bond. Are you currently out on bond or on any other type of probation in any jurisdiction, sir?
What charges you said? You understand what now?
So are
Last
you out
part.
on bond are you out on bond anywhere right now?
Yes, sir. I had bonded out. I went to court the
is
other
that
day.
there in Jackson County?
Yes, sir.
Okay, let's do this then. What I'll do this morning, I'm going to appoint the public defender's office for purpose of first appearance only here this morning on these set of charges. Mr. Barrett, anything you want me to consider before setting a bond?
No, sir.
Anything from the state, Mr. White?
If he is currently on bond, we would ask that you revoke the bond in his other case and would ask for random urinalysis.
All right, so what I'll do this morning, Mr. Benbow, whatever case number that is there, and it may be the clerk's office joining us by Zoom there, or the state attorney's office, but Mr. Jailer, if you'll just make sure that they know at this time, I'll go ahead and order that Mr. Benbow, his bonds be revoked on that particular set of charges that he's out on bond. So at this time, he'll be ordered to be held without bond on those charges. However, on the new charges, I will set bonds on the fleeing and eluding. I'll set those at $15,000 each. On the aggravated assault, I'll set that at $5,000. Oh, let me finish, and then I'll promise I'll give you the opportunity to speak. Okay.
Yes, sir.
At the aggravated assault with a deadly weapon, I'll set that at $5,000. The driving license suspended or revoked habitual at $5,000. Leaving the scene at $1,000. Carjacking at $15,000. Criminal mischief at $5,000. The concealing physical evidence at $5,000. Obstructing without violence, $1,000. Possession of controlled substances at $5,000. That would be ×3. And then the failure to register a motor vehicle at $1,000. I will also order random urinalysis at the court's direction.
Because I've got different charges than you do. I've got
I've got
the possession of the controlled substance alpha, and then a possession of controlled substance, the cathinone, and then I've got a possession of meth with intent to sell, manufacture, or deliver.
Right. Oh, yes.
Okay, and I didn't. Okay.
I'm sorry.
Hold on one second, Mr. Bimbo. We'll give you a chance here just a second. We just want to get this straightened out here. So, Mr. Barrett, you're talking about the face sheet here. I do see the possession of meth. So I think I counted that as a possession. Is that what you're saying, Mr. Barrett?
Let me look at the actual charge.
With intent to sell.
List.
Hold on. Mr. Bimbo, I'm not trying to be rude to you. I just don't want you to say something that could come back and proceedings are being recorded. I don't want you to say something that the state could use at a later date and time, okay?
I see 2 third-degree possessions and 1 second-degree possession.
2 third degrees and 1
I
second.
see the possession of the CS alpha P IHP, and then the possession of the cathinone, and then there's a possession of meth within.
That was just reading this possession here. So let me do this, and I'll back up and one of the
2
5,000.
third degrees and 1 second degree judgment.
Yeah. So the possession of a controlled substance, the PHIP, that's a 5,000. Possession of a controlled substance, cathinone is 5,000. The possession of meth with intent to sell, manufacture, or distribute would be 15,000. So, officer, did you need me to repeat that, or you got all those?
I believe I got it.
So, Mr. Bimbo, is there anything about what we've done here this morning on these new charges that you have a question about? I don't want you to talk about the facts of the case or If you disagree with the charges, because what happened here this morning is we're just determining whether or not there's probable cause for the charge. Based on what the affidavit and complaint says, I do find there's probable cause for each of these charges. So I understand you might think you have a legal defense to some of them or all of them. But that's something that we would not present here today through testimony of yourself or anybody else. So we've done kind of what we need to do here this morning, but is there anything about the proceeding that you wish to ask about?
Yes, I know about the little bag of, little bit bag of.
No, don't talk about the facts of the case.
But
That's
I'm
what you're trying to get into, okay?
Right, but they said it's three different, is, from my understanding, is you saying they got three different drugs somewhere?
So the affidavit and complaint talks
I
about
see
there's
you
three, yes, sir, listen, there's three different types of drugs here. The possession of a controlled substance, which would be, they field tested it, and it was an alpha PIPH. And then there is a different set of controlled substance, the cathinone. And then there was also a substance of methamphetamine that apparently rose to the level the way it was packaged with charge as the intent to sell, manufacture, or deliver. So I understand you saying that might not be what happened, and there may be a defense to each of those, but that's something that I can't consider here today based on the fact that I've already found probable cause for each of the charges, okay?
Yes, sir.
All right. Good luck to you, sir. Gene Littles.
Can I ask one last question, sir?
Sure, go ahead.
I was just want to ask about the bond thing. You said,
The bond you were already on, the judge revoked it.
Yeah, typically what happens, Mr. Bimbo, if you're out on bond and you pick up new charges, one or it happened in this case to be a bunch. But if you pick up a new charge when you're out on bond, then that bond in the first case would be revoked and you're ordered to be held without bond until that case is resolved. If you resolve that case, then you would have bond set on these cases. But I would anticipate that typically what the state attorney's office will do at this point in time is probably try to resolve all the cases at one time. So I would anticipate that you're going to be held in custody without bond until each of these cases are resolved.
In other words, don't go pay a bondsman any money on this new case because you can't get out till you resolve the older case. Do you understand?
Right. Yes, sir.
All right. Good luck to you, sir. Kerry Orkin.
Yes, sir.
Sir, looks like you're here this morning charged with driving under the influence. That's first degree misdemeanor, punishable by up to a year in jail, up to $1,000 in fines. Do you understand that's the reason why you're being held this morning?
Yes, sir.
All right, I did review the affidavit and complaint, found there's probable cause for the charge, find you're entitled to a bond. Are you currently out on bond or on any other type of probation in any jurisdiction?
No, sir.
I will appoint the Office of Public Defender for purpose of first appearance only here this morning. Mr. Barrett, anything you want me to consider before setting a bond?
Judge, just if he doesn't bond out or chooses not to, bring him up tomorrow. If they have regular court going on there, he may be able to resolve it.
All right, anything from the state, Mr. White?
No, sir.
Sir, I'll set. You had a question, sir?
Yeah, what did the gentleman just say?
I said, if you'll listen, the judge is fixing to set your bond conditions. If you cannot bond out or don't want to pay the money to bond out, the judge will allow you to be brought back up again tomorrow morning when the regular court there in Jackson County is in session. We can't resolve a case from Holmes County, but the Jackson County judge will be back tomorrow along with prosecutor and someone from the PD's office. They will likely make you some type of offer tomorrow.
Okay.
Do you understand?
Yeah, that's the kind of the question that I had. I
All right,
sort of
well,
understood that.
listen, the judge is going to set your bond conditions.
Did it kind of get answered?
Well, yes, sir, but I'm a combat veteran and I'm trying to get back to my family. I was only here because my grandmother passed away. Now,
Well, let me do this, sir. Here's what I'm going to do. Those are things that unfortunately I can't take into consideration.
No, I'm just saying if I bond out, am I able to still come back tomorrow
Yes,
like
yes.
he's talking about so I can resolve
No,
the
not
case
tomorrow.
quickly?
If you bond out, they'll give you a court date down the road.
Okay, so is there a way that I could take care of that from home? Because I mean,
No, sir,
I'm
they
not
would
from
probably
here.
require
Not with
you
a DUI, you're gonna have to
you
be
would have
there
to
in
come back to
person for a
Jackson County
DUI.
there.
Okay, all right, yes, sir.
So here's what I'll do. Where do you live?
I live in Texas, sir, but my wife and my baby boy is in Reno, Nevada. I had came to take care of family, and I guess this is what happened.
All right, let me do this. And I'll
Accidents
go ahead and
happen
set
type of
that.
thing.
Let me do this. I'll set the bond at $1,500. Order that you have absolutely do not possess or consume alcohol while out on bond. If you don't make that bond, like Mr. Barrett said, they'll bring you up tomorrow morning before Judge Mercer, and I'm sure the state will make an offer to you to resolve your case.
Okay.
If you want to go ahead and make the bond, what they'll do today is they will give you a notice to be back in court. That means you have to be back in court in Jackson County on that day and time. That's the only notice that you'll get. If you do not show up for court on that day and time, they will issue a KPS for your arrest, and they will probably come and get you wherever you are, anywhere in the United States. So I would anticipate that it would be in your best interest to show back up and go forward with the case on that day and time. Do you have any questions about your bond or conditions?
Do you think that will be in this month at least, sir?
I'm not sure what the docket is, but I would anticipate it would probably be the beginning of May.
Or you could just put your patient pants on and sit it out at night. They'll offer you a chance to resolve it tomorrow. And then go back home to your family. Get it taken care of. Don't mess around with this, because Florida don't mess around with this.
Is usually, if you are this early in April, then I would anticipate they give you a May court date to resolve your cases there in Jackson County.
Or if you can stand just waiting overnight, they'll bring you up in the morning.
Okay.
Your Honor, Officer, I believe that's everyone there at the jail this morning for first appearance.
Yes, sir. That's everybody. Thanks, sir.
All right, y'all have a good
Your
one.
Honor, right quick.
Thank you, sir.
Oh, man. Did he just log off, Corey?
Yeah.
Oh.
Okay. So maybe I can tell you, Mr. Boykin. So, Mr. Boykin, here's what usually happens. Usually, like they were saying, if you don't bond out, you can be brought back up tomorrow, and Judge Garcia will actually make an offer for you tomorrow. However, even if you do bond out, you may be able to come back to the court tomorrow morning, and Judge Garcia may be able to resolve your case tomorrow morning, even if you are bonded out. Okay?
Okay. Yes, sir.
All right. So that's your option right there.
Okay. Thank you so much, sir.
All right. You're welcome. Thank you, Corey.
We will go on the record in the matter 24 CM 202, State of Wisconsin versus Andrew Cote. The state appears through Assistant District Attorney Holly Rockow in person. Mr. Cote appears in person in custody with counsel Joel Feliski. We're set today in this matter for a plea and sentencing hearing. The parties have reached an agreement. Mr. Feliski, can you please recite the agreement for the record?
Yes, Your Honor. Mr. Cote has agreed to plead to one count of misdemeanor disorderly conduct, with the remaining counts in the complaint dismissed and read in, and a joint recommendation by both parties for court costs totaling $443.
And I believe he was in the process of a revocation. Was he revoked, or did?
Yes, Your Honor. As of yesterday afternoon, the final decision from the administrator came in, and he has been revoked, and he will be sent to Polk County for sentencing.
Okay. And what charges was he convicted of in Polk County?
I believe they were substance use related, Your Honor. I was not originally opted into that case. That was my predecessor, Mr. Pollack. Unfortunately, I cannot speak to any detail as to the nature of those charges.
All right, thank you. I can just pull it up. I just am curious. Would it be for the 24 cases or for a 21 case, Mr. Cote?
24.
Oh, 24 case. Okay, so for the 24 cases, possession of amphetamine as a repeater, possession of cocaine, a misdemeanor, it looks like. All right. Okay. Basis for the agreement and why it's in the public interest, Ms. Rockow?
Your Honor,
Mr. Schmidt negotiated this case with Mr. Pollock and Mr. Flasky. But based on my review of the file, I believe that this was based upon the facts and circumstance surrounding the case being relatively minor in terms of the disorderly conduct. There was, of course, the violation of the bail, but that was the Polk County bail. And so it looks like that was all resolved with his latest revocation. So those bail jumps being dismissed and read in as appropriate for that reason. And I don't believe that any additional confinement or supervision is going to be necessary as he is facing that sentence for the revocation.
Okay. All right. So we do have victim SB in the courtroom here today, and Ms. Bauer, SB would like to make a statement. Is that correct?
Yes, Your Honor.
SB may come up here and have a seat at the black desk, and you may provide a statement. If you are going to read something, please read it very slowly so my court reporter can take everything down.
Of course.
I was in a relationship with Andrew Cothey for almost a year. Since we started dating on January 22nd, 2024, I knew there was something wrong with the way he would talk to me or even act. But I was in love. On April 5th, that's when the real anger started. Almost every day from then until the 22nd of October, or the 21st of October, there were fights. He would hit me, but he always thought that he could just make it up. On October 21st, we were at a friend's house and he was on the phone with a friend. And just out of nowhere, he called me the B word and then threw a car manual at me. Seconds later, he would spit in my face. But once again, made it up, told me he would never do it again. But just a couple hours later, my world flipped around. On October 22nd, about midnight, we left the friend's house and he drove to a parking area in Grantsburg. I ended up falling asleep in the passenger seat, like I always had. He ended up waking me up to ask me where the drugs were. I handed him what he had wanted and I went back to sleep. He woke me up again and asked me for the other bag. I said I gave him everything I had and I didn't have anything else. He got angry and started firing the flare gun out the sunroof. The second time he woke me up, he asked me once again. And I told him the same thing I had told him the first time. This time he got mad at what I had told him and he ripped off the rearview mirror and threw it in the back seat. Then he took the passenger visor and ripped it off the car and then hit me in the cheek with it. The third time he asked, I told him the same thing. This time he ripped off my glasses, bent them, and broke them. So I thought I was going to try and call for help. He ended up taking my phone and with his two hands, literally ripped it in half. The fourth time he woke me up, I kept repeating what I had told him every time.
Wait, fourth time he woke you up? How did you go back to sleep each of those times as he was progressively getting more and more irrational, more and more outrageously violent? How did you go back to sleep? She doesn't deserve what happened to her. I am not blaming the victim. I am just genuinely curious how someone rips off a rearview mirror and throws it in the back seat, assaults you, grabs your glasses, breaks them, rips your phone in half, and each time you go back to sleep.
And this time I looked at him and I looked in his eyes and they were black. It was like Andy was gone and someone else took over. The next thing I knew, he started bashing my head against the passenger window. And all I kept thinking was, I have to get away, otherwise he's going to kill me. So I had got him calmed down enough to where he would drive to Dollar General where the van was parked. We were gonna move it, but we decided he didn't want to because he was getting tired. He let me drive the car, and I knew that was the only way I was going to get out. I drove the car to the Frederick Trailer Park where I knew I would be safe. I parked in the front entrance and stopped. He woke up and started yelling, calling me every name in the book, but I was only able to grab my purse, and that was it. I started walking to my friend Jen's house in the park, and I got there and she asked me if she could call, and I said yes, and fell to the ground. The cop from town came and my body started going numb. I ended up throwing up and passing out. Not knowing what was going on, they called the EMTs, and I went to the hospital and had a CT scan. Your Honor, this is so painful for me. I have anxiety and panic attacks now every day. I am actually on nightmare medicine. I don't know the name of it, but I have nightmares every night, every time I sleep, of what he did to me. I am in therapy almost either 1 or 2 days a week, and I will be on therapy for at least 3 years, she said. This was 6 months ago, and yet it still gets to me every day. I don't know how I'm going to move on from this. So I'm asking you for some stipulations: 90 days in jail, no contact with me, my property, or my roommates, no possession of firearms, anger and drug treatment, and probation. I don't think it's fair that I have to live with this every day and he would get away scot-free. He has made it to where I don't feel safe, and I will be putting 2 restraining orders on him for both counties. I can't go outside by myself. I can't go to the store by myself. He's already threatened me enough. Thank you.
Thank you. Just a bit of information. You only need 1 restraining order. It covers you everywhere.
Okay.
So
Thank
you don't
you.
need to go to both counties. Thank you for your statement.
Thank you.
And for the record, and I'm sure that, well, maybe the state had more information, but that's not any of the information that is contained in the criminal complaint. The criminal complaint is very sparse and just indicates that there was an argument and it may have escalated, but what I have access to doesn't discuss the level of what that argument may have been or consisted of. So, all right, so then the agreement, Ms. Rockow, now again, after hearing the victim, what is the basis for the agreement in the justice or in the public interest?
Well, Your Honor, I think some of that information wasn't information that the state had when this case was charged or when this offer was made. It's not my file, but from my review, I didn't happen upon that, what was described just now. So based on the facts that are contained in the criminal complaint.
And again, and I'll state, you're probably hearing or seeing it for the first time as the court is, because the criminal complaint is one small little paragraph that just describes a fight that occurred and that it may have escalated a little, but none of the detail.
Right. But Your Honor, again, Mr. Cothey has been revoked in Polk County on some more serious charges and is going to be presumably serving a jail sentence. I think at least one of those had some stayed jail time. So I think that he's going to remain in custody for a while. I don't believe that based upon the facts that anything more is necessary here. I think that the bail jumps again were associated with the Polk County cases. So I don't consider that to be, of course, he violated his bond.
I think more is necessary. I personally feel like he should have to have consequences specifically for these events.
But I think that the focus here in Burnett County should be the disorderly conducts. And I don't think that any jail or probation is appropriate. I do think that costs only is sufficient to protect the community.
All right, and my guess is that the state wasn't aware of, I'm gonna guess also maybe the police were not aware of the extent of the argument or what occurred that night, because otherwise I'm questioning why a battery wasn't charged.
Right, I don't have any information about bruising or pain or injury in the file as I review this.
All right, okay. And he is being revoked, and I'm taking judicial notice of 24 CF 15, 24 CF 224, and 24 CF 310 Polk County matters, in which he has now been revoked on those matters and will go face sentencing in Polk County. I believe in those cases, there is no stay jail time. That was that fictitious thing that some judges do, and they fictitiously say, I'm having that fictitious conditional jail for probation to use if they wish to do.
Understood.
And so with regards to the charges in Polk, he does have the possession of amphetamine with the repeater. So that means the maximum possible penalty of 1 year he could face, with the increase of no more than 2 years for that underlying misdemeanor in Polk County. But that's for Polk County to deal with and for you to deal with in Polk County. And you were under bond jump or under bond conditions in Polk County when you violated your bond here by engaging in the criminal actions here in Burnett County. And for the record, and this is, I guess, for the victim as well as you, Mr. Cote, for you to be aware of, and perhaps the reason why these were simply charged as disorderly conduct is because of the little bit of information that was provided the day of the incident, at least that I have in front of me. And usually what's in the criminal complaint is what is been provided to the police in the police report. So there's not much. This is the first time that I believe perhaps even the state is hearing the depth of what may have occurred that night. So he's pleading guilty to 1 count of disorderly conduct, is that correct? And the other count will be dismissed and read in, and he's facing the other charges in the bail jumps in Polk County?
To my understanding, Your Honor, that is correct. It's a plea for 1 count of disorderly conduct, with the remaining counts in the complaint to be dismissed and read in. As has been stated, he is currently he has been revoked from probation, and he will be sent to Polk County for sentencing after revocation. I would like to take note that he has been in custody on this revocation hold stemming from this incident since October 31st of 2024. He has accumulated approximately 155 days of jail credit. The conduct has again prompted revocation here, in the maximum sentence for a charge of disorderly conduct has been vastly exceeded. He's set for close to double the amount of time he would for the maximum sentence on this. The public, I believe, has been sufficiently protected. He will continue to reside in custody, awaiting sentencing after revocation. I believe he will be returning to active supervision for his Polk County charges as well. In entering this plea, he is taking accountability for this and does wish to move on. For those reasons, I would ask the court to adopt the joint recommendation. Thank you.
All right, can I have the plea questionnaire waiver of rights form, please?
Yes, Your Honor. May I approach?
You may. So I have in front of me the plea questionnaire waiver of rights form, Mr. Colty. Did your attorney go over this document with you thoroughly?
Yes, Your Honor.
Did he go over it word for word?
Yes, Your Honor.
And do you understand it completely?
Yes, Your Honor.
If you didn't understand it, did you ask him to explain it?
Yes.
And he did so?
Yes, Your Honor.
So you're 37 years old, you have 12 years of schooling, you can read, write, you understand the English language.
Yes, Your Honor.
That's your signature on the second page.
Yes, Your Honor.
You're pleading guilty to 1 count of disorderly conduct, is that correct?
Yes, Your Honor.
Did your attorney go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face?
Yes, Your Honor.
No mental illness or disorder and no alcohol, medications, or drugs?
No, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights, and each of these rights is listed on this document. Did your attorney thoroughly go over these rights with you?
Yes, Your Honor.
Do you understand them completely?
Yes, Your Honor.
Do you understand that by pleading guilty, you're waiving and giving up these rights?
Yes, Your Honor.
Do you need me to go over these rights with you in any more detail?
No, Your Honor.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
You understand the state would have to prove on or around October 21st, 2024 in Burnett County, Wisconsin, while in a private place you engaged in indecent, boisterous, abusive, and otherwise disorderly conduct, which under the circumstances did tend to provoke a disturbance. Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalty? The maximum possible penalty of this crime could be a fine of up to $1,000 or up to 90 days of incarceration or both. Do you understand that?
Yes, Your Honor.
Do you also understand I have a recommendation from both of the counsels, both of the attorneys here, a joint recommendation for costs only, that would be court costs and DNA surcharge, etc., costs only for $443. Do you understand that is simply a recommendation to the court?
Yes, Your Honor.
Said differently, that means I'm not bound to follow that, and I could sentence you all the way up to the maximum possible penalty, and I could do that here today if I thought it was necessary and warranted. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney?
Yes, Your Honor.
And again, that's that document that basically says what happened that day and why you were charged with the crime. And albeit it is very short and it doesn't have a lot of facts and it doesn't have as many statements or factual assertions as the victim did state here today, but as it's stated in the probable cause section of that criminal complaint, for the most part, are those facts accurate?
Yes, Your Honor.
Did you get into an argument and into a fight with SB?
I don't believe so.
You don't think you did?
I just know that when she dropped me off, she was yelling stuff at me when I drove off.
So what did you do?
I just drove off.
You didn't do anything?
Oh,
You didn't provoke a disturbance?
no.
Good, we're going to trial. Thanks. We'll set this matter for a trial. Okay? Sounds like we're going to have a trial on 2 disorderly conducts and 2 bail jumps. That sounds good to me. So maximum possible penalty for 2 disorderly conducts, up to 90 days of incarceration, and for 2 bail jumps, up to 9 months each. Because if you're indicating you didn't do it and you're indicating that you're innocent, by golly, the state has to prove beyond a reasonable doubt. And so I think we're going to set the matter for trial, and I think we need 1 day. Let's set it for trial here today, Miss Rockow. Is this going to be a your case or is this going to be a Mr. Schmidt case?
By golly, she's almost giddy.
This is Mr. Schmidt's case.
Okay, let's get the matter set for trial and we can do it. I can presume you're going to be in custody for a while since you are revoked on your Polk County matters. But we don't have a problem getting you back here for a trial. We have a really great lieutenant who runs our jail very well. And we have the ability to do transport. So let's get this matter set and let's get it set for sometime soon. And we have the victim here so we can make sure that we have a date that works for the victim as well. How about June 24th? It is on the Assistance Week, but June 24th sounds like a good day to have a trial. How does that work for you, Mr. Feliski?
I'm available that day, Your Honor.
Excellent. So we'll have a trial on June 24th. That'll be a trial because, again, if you didn't do anything that day, that's what your assertion is here, Mr. Colte. The state has to prove it beyond a reasonable doubt that you engaged in any type of conduct that would be disorderly, and whether or not you were on a bond in Polk County and whether or not you violated that bond and you did so knowingly. So that's what we're going to do. June 24th, we will have a trial. We only need one day. That works for victim, Ms. Bauer? Yes, sir. Excellent. Now let's get to my final drop dead date. That means, Mr. Colte, that is the day that I will no longer take any type of agreement, okay? I won't accept any agreement in this case, all right? And so that means the matter will go to trial and you will be able to have your attorney state your, or actually have it'll be the state trying to prove the case and your attorney will be able to defend defend you and your claims at this matter. But on May 29th, that'll be the last day, the drop dead date for any agreement that'll be reached. And quite honestly, to me, the court does not find a disorderly conduct with costs only, especially hearing the statement from the victim to be in the public interest. So let's do May 29th, Mr. Feliski, May 29th. Well, you said that this is going to be a Schmidt, even though it's on that. So let's do May 19th, drop dead date. May 19th, can you do 10:45?
Yes, Your Honor.
All right, May 19th at 10:45, we're going to have our drop dead date for any agreement that can be reached in this matter. Otherwise, we will go to trial. We don't have to worry about lab. We have confirmation that victim will be able to be present in here for the trial. We're good to go. All right. Thank you. We're adjourned. We'll see you then.
Thanks, Your Honor.
This is in the District Court of Greenwood County, Kansas, case entitled State of Kansas versus Stephan Lopez de Luna. It's case number 2024 CR 119. Richard Paw appears defense counsel, Marianne Shirley on behalf of the state of Kansas. The defendant appears at the Greenwood County Jail Zoom location.
If this guy looks familiar, it's because he's been on here a few times already. I've covered Mr. de Luna just a little bit. He's an FTC that just keeps appearing and reappearing.
This matter comes before the court at this time for further proceedings. Status and possible plea is indicated. What announcement is made at this time?
Your Honor, in 2024 CR 119, Mr. Lopez de Luna is going to enter a no contest plea to count one, that being methamphetamine. Counts 2, 3, and 4 will be dismissed. And we will also have an announcement in 24 CR 167 as well, Your Honor.
All right, what is the announcement in the other case?
The announcement in the other case, 24 CR 167, will be a no contest plea to count one, criminal damage, a level 9 non-person felony. Count 2 would be dismissed.
All right, a no contest plea on count one, criminal damage to property. in 2024 CR 167 regarding 24 CR 119. The no contest plea would be to which count?
Count one, possession of
All right.
methamphetamine.
Of all other charges in that case being dismissed, Mr. Paul?
Yes, Your Honor.
Ms. Shirley, has Mr. Paul announced consistently with your understanding as to how these two cases would be handled?
He has, Your Honor.
Mr. Lopez de Luna, do you agree as to what your attorney has announced here this morning?
Yes, Your Honor.
All right, I've got a whole number of questions I need to ask you regarding the taking of a plea of no contest in these cases. If there's something you don't understand, I'll give you additional time with your attorney. If you need that time to confer, let the court know, okay?
Yes, sir.
State your full legal name for the record.
Esteban Lopez de Luna.
How old are you right now?
I'm 19.
What's the highest level of education that you've attained?
12th grade.
Do you believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here today?
No, Your Honor.
Have you ever been adjudged to be mentally ill?
No, Your Honor.
Are you currently under the influence of alcohol or any drug?
No, Your Honor.
Are you currently taking any type of prescription medication?
No, Your Honor.
Are you supposed to be taking mental health meds that you are not currently taking?
I have one mental health med that I'm taking right now, actually, yeah.
Okay, and what is it?
You know what it is? I don't know what it's called.
No, I have no idea. 1 second, I can look.
All right, well, what I'm trying to get to here is whether you feel like that you're impaired in any way as a result of this medication.
No, Your Honor.
Do you believe you have a full understanding then of what's going on here in court?
Yes, Your Honor.
All right. Did you receive a copy of each of these charging documents in these two cases that are pending?
Yes, Your Honor.
Do you understand the nature of the charge of unlawful possession of methamphetamine?
Yes, Your Honor.
Do you understand the nature of the charge of felony criminal damage to property?
Yes, Your Honor.
Do you understand that when you enter a plea of no contest, you're not admitting that you did these things, but you're also not contesting that you be convicted just the same? Do you understand that?
Yes, Your Honor.
And you understand when you enter pleas of no contest, you're giving up any legal defenses that you might have had to these charges?
Yes, I do.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, and that you can present evidence at your trial on your own behalf and subpoena your own witnesses to court?
Yes, Your Honor.
You also understand that at such a trial, you personally would have a privilege against self-incrimination, which means that you could testify in your case on your own behalf if you wanted to, but no one could force you or compel you to testify against yourself if you didn't want to. Do you understand that?
Yes, Your Honor.
You understand that when you enter pleas of no contest, you give up these valuable trial rights?
Yes, I do.
Are you aware that you have a right to a trial by jury and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, Your Honor.
You understand that when you enter pleas of no contest, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt?
Yes, Your Honor.
Do you understand that you have a right to appeal a guilty verdict if you have a trial?
Yeah, I understand.
You further understand that you may appeal your sentences after entering pleas of no contest, but generally you may not appeal your judgments of conviction after you enter such pleas?
Yes, Your Honor.
Are you aware of the possible sentences that could be imposed as a result of these no contest pleas that you're attempting to make?
Yes, Your Honor.
Let's go over those. In the 167 case, you're pleading to criminal damage to property. It's a level 9 non-person felony. In the most favorable criminal history category of I, you can receive as little as a 5-month sentence. In the worst criminal history category of A, you can receive up to a 17-month sentence. So the sentencing range is 5 to 17 months, depending on your criminal history. We do not know with certainty today what your criminal history is. That will be researched by the Court Services Department And based on the outcome of their research as of the date of your sentencing, that determines where you fall along the level 9 line, and then you'll be sentenced accordingly. Do you understand that?
Yes, sir.
You also understand that you could receive up to a $100,000 fine for that offense.
Yes, Your Honor.
The other charge that you're attempting to plead to here is possession of methamphetamine. That's on level 5 of the drug offense grid. In the most favorable criminal history category of I, you could receive as little as a 10-month prison sentence. In the worst criminal history category of A, you could receive up to a 42-month prison sentence. So the sentencing range is 10 to 42 months in prison, depending on your criminal history. I need to point out to you that on that grid, if you have even as much as one person felony on your record, you are presumptive prison. Do you understand that?
Yes, Your Honor.
Do you also understand that in the other case, if you have 2 or more person felonies on your record, you'd be presumptive prison in that case?
Yes, Your Honor.
On the drug offense, do you understand that you could receive up to a $100,000 fine for that offense as well?
Yes, Your Honor.
In addition to any fine, are you aware that you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders?
Yes, Your Honor.
You also realize, as a direct consequence of this plea, you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing.
Yes, Your Honor.
You also understand that both probation and post-release supervision periods generally start at 12 months in duration, but can run up to 60 months under some circumstances.
Yes, Your Honor.
You also understand that the Kansas Sentencing Guidelines Act has many special sentencing rules. If any of these special rules apply to you and your situation, do you understand that it could affect your eligibility for probation or otherwise affect your sentence?
I understand, Your Honor.
Have you had an ample opportunity to discuss legal matters like this with Mr. Paw?
Yes, I have, Your Honor.
Want any more time with him privately now before we go further?
I don't need any time, Your Honor.
All right. Are you satisfied with the services and advice given to you by your lawyer?
Yes, I am.
Now, these no contest pleas that you're attempting to make, have they been based upon any threat or promises as to what this court will do in regards to your sentences or any other type of threat or promise?
No, Your Honor.
I need to point out to you that if there are any plea agreements between your counsel and the county attorney's office regarding sentencing recommendations, this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, Your Honor.
So how do you plead to count 1 in case number 2024 CR 167, level 9, non-person felony, criminal damage to property?
No contest, Your Honor.
And how do you plead to count 1 in case number 24 CR 119, unlawful possession of controlled substance methamphetamine, a level 5 drug felony?
No contest as well, Your Honor.
Shirley, if you provide a concise statement of factual basis as to each of these 2 charges.
In case number 24 CR 119, on or about June 1st of 2024, he was observed operating a motor vehicle at 41 miles an hour in a 30-mile-an-hour zone, pulled into Sonic in Eureka, Kansas. At that time, he was unable to provide a driver's license that was valid. The K-9 unit walked around the vehicle and alerted. Based upon the alerts and the training of the officers, the vehicle was in fact searched. And at that time, they found a smoking pipe with methamphetamine, and it tested positive through the KBI for methamphetamine residue. He admitted to smoking earlier in that day. With regard to case number 24 CR 167, while he was incarcerated at the Greenwood County Jail on or about September 10th of 2024, he put paper in the sink drain and clogged the toilet with food. The plugs caused the drains to overflow and flooded the Greenwood County Sheriff's Officer. Flooded the water was running down the walls in the downstairs in the office, saturated the computer system, the sheriff's lobby, the televisions in the sheriff's office, and the new cameras, control cameras. And this was in excess of $1,000, but less than $25,000. And that, of course, was in Greenwood County also.
All right, thank you, Ms. Shirley. All right, Mr. Lopez de Luna.
Yes, Your Honor.
At this time, do you make pleas of no contest and accept conviction for unlawful possession of methamphetamine, a level 5 drug felony in the 119 case?
Yes, Your Honor.
Do you now freely, knowingly, and voluntarily enter a plea of no contest and accept conviction for criminal damage to property, a level 9 non-person felony in the 167 case?
I do, Your Honor.
Pa, do you know of any legal reason why the court shouldn't accept this defendant's plea?
No, Your Honor.
Ms. Shirley, are you aware of any such reason?
No, Your Honor.
Mr. Lopez de Luna, are you aware of any legal reason or any other good reason why the court shouldn't accept your pleas here today?
No, Your Honor.
Court will accept the no contest pleas made by the defendant and finds that those pleas are made voluntarily. An understanding of the nature of the charges and the consequences of the pleas and a factual basis for each of the 2 charges does exist. The court finds the defendant guilty pursuant to acceptance of his no contest pleas and adjudges him therefore convicted of the crimes of criminal damage to property, a level 9 non-person felony in case number 2024 CR 167, and in case number 2024 CR 119, court accepts the plea and finds the defendant guilty of unlawful possession of methamphetamine, a level 5 drug felony. All other charges of these 2 informations are dismissed pursuant to plea agreement. Court will order pre-sentence reports be generated to accurately determine the defendant's criminal history, and the court will set both of these matters for sentencing. Currently contemplating Thursday, June 5 at 1:15 p.m., Mr. Paul?
Yes, sir. 1:15.
1:15.
I will be there.
Lopez de Luna, court's going to order you to comply with any pre-sentence assessments that may be done. You may have a risk needs assessment. You're likely going to have a substance abuse evaluation as well. Those need to be fully complied with and completed at the earliest possible time so that we don't have to delay your sentencing.
I understand, Your Honor.
1:15 p.m. Thursday, June 5 for further proceedings in the case. But Shirley, are you aware of anything further that needs to be addressed here?
No, Your Honor. Thank you.
Mr. Paz, or anything further the court needs to address?
Judge, I would like to address bond. Mr. DeLuna is in a unique position. He does have another couple of cases that are in front of Judge Crum. Those are going to be heard, I believe, on May 8th. The part of the plea agreement today was part of a global resolution for the other cases. I do not represent him on those other cases. However, I believe that at sentencing, he should be presumptive probation on these, and he has been in custody since September. What I would ask this court to do is basically modify his bond, and then at his plea in May in front of Judge Crum, if Judge Crum modifies that bond pursuant to a plea, this bond can then go into effect.
All right, Ms. Shirley, do you have any information in your file as to why a $100,000 bond was set in this case initially? That's a very high bond. There was obviously some great risk and anticipated about him showing up, or I don't think that bond would be set that high. Do you know what those factors were?
I do not. I do have the other cases. Basically, the cases that are pending are trafficking in contraband and theft of a vape pen in the jail. There is an additional count of the second occurrence of flooding the jail. And the third case is an aggravated battery, which occurred while he was in custody. But as far as the original, I do not have any information about that, Your Honor.
Judge, I think I can shed some light on that.
Go ahead, Mr. Paul.
Judge, back on July 13th of 2024, he had a $5,000 surety bond. Then subsequently on August 1st of 2024, there was a motion to revoke that bond because he had not returned to his address where he was living in Wichita. And I believe at that point, that's when the $100,000 bond was set. And that initial $5,000 was revoked.
Correct. Yeah, he's in cell 1 in North Walk.
Turn myself in as well.
And that is correct. He did, when he found out that his bond was revoked, he did turn himself in almost immediately to the Greenwood County Jail.
Well, the notes in the case management system indicate that in the 119 case, the original bond was set at $15,000 cash or surety. At the next hearing, Mr. Paul, where you were involved, it was reduced to $5,000 cash or surety with an EMD. That bond was eventually revoked. The court will reinstate the $5,000 cash or surety bond in case number 2024 CR 119. The case management system notes would indicate that in the 167 case, and this is the one I was referring to earlier, bond was set at first appearance at $100,000 cash or surety. I don't see any even request to review that bond that's ever been made, or at least a ruling that's ever been made subsequent to that time. What concerns the court is that Mr. Lopez de Luna has picked up cases, new cases, while in jail. If he picks up new cases while he's in jail under direct supervision from the sheriff's office, wouldn't he be a risk to the community to turn loose pending sentencing in the case? Mr. Paul?
Judge, his track record isn't the best while he's been in custody, but while he was out on bond, he was not charged with any additional crimes. So I don't know
He
if
just commits his crimes while he's in custody.
Unfortunately, that is the track record, Your Honor.
That is Mr. Paw doing the best he can with what he has, which isn't much.
We'll leave bond where originally set in the case at $100,000 cash or professional surety required. I don't know what kind of criminal history we're going to be dealing with this guy. If Crumb's case is resolved, he's going to have multiple felonies, which are going to count against his criminal history at time of sentencing in this case. Now, whether that will make him presumptive prison or not, I don't know, because I don't know the rest of his criminal history, which might count in this case. Plus, he's going to have multiple assessments he's likely to need done. I'm gonna leave the bonds at $5,000 in the one case. Were originally set $100,000 on the other. Pending sentencing in the case set for June 5 at 1:15. Mr. Lopez de Luna, regardless of how much trouble you believe you're in, it's in your best interest to fully comply with these assessments when you're asked to do them. That will facilitate you getting sentenced and perhaps even facilitate you achieving some level of freedom. So we'll see you on June 5th, and we'll check the status of all of your cases at that time.
All right, thank you, Your Honor.
All right. Ms. Shirley, anything else?
Nothing. Thank you, Your Honor.
Mr. Paw?
No, Your Honor. Thank you.
The Lopez de Luna matters will currently be in recess. This meeting may be ended for all at this time.
You're on Zoom?
Yeah.
You're gonna be live right now. Give us an
Good morning. Can you hear me, sir?
I'm gonna turn the volume up a little bit, ma'am. I can hear you.
Okay, and what is your full name, please?
Jared Codair Content.
Thank you, Mr. Content. We are live on the record in case 25-4608 SD. Sir, you're zooming in with us from the Antrim County Jail this morning. Also zooming with us is Attorney Mistally. She is a defense attorney here to assist you with the bond violation arraignment process. What I'd like to do is open a private breakout room. It's a place where you'd be able to have a private conversation with Ms. Mistally about these alleged bond violations and how you may wish to proceed. Are you comfortable going into a breakout room? Do we know, was Mr. Fragel?
He doesn't have an email. I did not call.
Okay, so it appears that we may have to schedule this for Tuesday if just because we didn't have a way to contact Mr. Fragel to see if he was going to be here today to assist in this.
Okay.
Mr. Content, would you prefer to have Mr. Fragel here?
Would I have to sit in the jail until Tuesday if that were the case?
Unless we could reach him to do this. So
I would prefer to use the court appointed lawyer rather than wait until Tuesday.
Yeah, since he has retained counsel, I'm not authorized to, I didn't know he had
Right.
retained counsel. I'm not authorized to do that.
So, Mr. Content, it would have to be a situation wherein your attorney would have a conversation with Ms. Mistally and ask her to cover for him.
Okay.
So at this point, because you have your retained counsel, we will try to reach out to him and get this rescheduled. We'll send a notice to you as soon as we get in touch with him and get him in here to assist, okay?
Okay, Your Honor, is that something that I would be released and then would have to come back in, or would I have to sit over the weekend until Tuesday in order to do that?
Well, you know what might help is if you did you call your attorney?
Yeah, I called them yesterday twice and texted them, and I never heard back from them.
Okay, so he is aware. We'll see what we can get set up, but you would have to sit until, because this is a no bond warrant. So
if at all possible, I'm concerned about losing my job. Would it be possible to represent myself and not have any representation? I would rather not sit in jail over the weekend.
I don't blame you for that, but because you have an attorney, I would strongly recommend that and it sounds like you did reach out to him.
I
So,
did.
okay, we'll see what we can do about getting this rescheduled, okay?
Your Honor, I would rather not wait until Tuesday.
Mr. Content, it's out of your hands at this point, okay? We're
What if I
going to
choose not
try
to
to
have
get your,
representation?
so you're choosing not to have representation?
Yes, I would rather represent myself in this specific case rather than wait over the weekend.
Which is his constitutional right.
I don't feel comfortable having you phrase it that way. So if you would please knock on the door and let the officer know you're all set.
Okay, ma'am.
Thank you. So don't disconnect that. We have other people to see.
I understand.
It may be helpful if you knocked on the door, sir, rather than.
I did.
Well, no, get up and knock on the door behind you, please. And is Ms. Shipley being seen for 2 new arraignments and a bond violation arraignment?
Yes.
That is correct, yes.
Okay, all right.
Thank you. So
Did she have an interim bond?
she did have an interim bond, and let me see. It was a PR bond with no contact, etc., that allegedly let's see here. I don't have, let's see if she's in there yet. All right, I have to go grab something. I'll be right back.
What's your name, please?
Hello?
What's your name, please?
My name is Joyce Shipley.
Okay, so we're gonna wait for a moment for the magistrate to return, and then she's going to put you and I in a breakout room. I'm Ms. Mistley, I'm the on-duty arraignment attorney, and you and I will have a couple moments to speak privately, but not yet.
Okay.
Still, okay.
Ugh, sorry, I don't know what to do with my hair. I'm sorry.
Okay, good morning. Thank you for waiting. And what is your full name, please?
My name is Joyce Megan Shipley.
Thank you, Ms. Shipley. We are live on the record in case 25-4696 SM. We also have a companion case 25-4668 SM. We're here for purposes of arraignment in both matters, as well as an alleged bond violation arraignment as well. So what I'd like to do is open a private breakout room. We have Ms. Mistley Zooming with us. She is a defense attorney provided to us through the Michigan Indigent Defense Council. And it's a private place where you would be able to speak with her. Are you comfortable going in a private breakout room with her?
I guess. I don't know what that means really, but
It's a private virtual room that you'd be able to talk with a defense attorney about the allegations that you're facing right now, the nature of the offenses, the maximum possible penalty, your rights, and how you may wish to proceed. And it's a private place. So right now I sent you an invitation to join the breakout room. So it would be a place where you'd be able to speak privately with her.
okay. So hit join.
Yes, please. And then I'll speak with you when you come back, okay? Welcome back, ladies. We're back on the record in cases 25-4696 SM as well as 25-4668 SM. Ms. Mistley, did you have an opportunity to speak with Ms. Shipley about this case?
Yes, I have reviewed the misdemeanor complaints with her, along with the maximum possible penalties. We will be tendering to the court pleas of not guilty and requesting the assignment of an attorney to represent her throughout the cases.
Okay, thank you.
Oh, I'm sorry. With regard to the alleged bond violation, she's also entering in that guilty plea, and we'd like a hearing with her attorney present at that hearing with her.
Thank you for that. Okay. We're going to complete a petition together, Ms. Shipley. I do need to swear you in for this. I need you to keep your shirt on.
It is.
Thank you. Please raise your right hand.
Listen, I'm not a criminal. I'm not like here to do criminal activities.
Or affirm that the information you're about to give me for this petition for court-appointed counsel is the truth to the best of your knowledge?
To the best of my knowledge, yes.
Thank you. You may put your hand down. What's a good mailing address for the court to use?
Calcasta.
Thank you. And do you have a physical address where you are residing? We didn't get a call with your
No, I
new
don't.
address.
I don't have a phone. It was left, and I don't have an address, no. And I've called the homeless shelter since last, was it August? I don't know. I've been calling them since Labor Day last year for room, for shelter, and there is nowhere for me to go. There's nowhere
Okay.
for me to go.
But so we can use the PO box. And do you have an email address you use?
No. It's full.
What's your legal marital status?
I don't know. Legally, I don't know how to answer these questions anymore because everything has changed.
Are you married, divorced, single?
You mean like with a piece of paper with my signature on it and like a new
Yes.
last name?
Yes.
No. I don't know how to answer your questions though, because everything is very different. And I swore that I would tell the truth to the best of my knowledge. And I'm struggling to do that because everything has changed. And I want to be honest with you.
I appreciate that. Thank you so much. Okay. And do you have any minor children that you support?
I have 3 children, but they're with their dads.
Do you have employment?
I don't know how to answer that.
Okay.
I'm
Do you
doing
have
exactly what I am being cued to do. People give me the cues
Yes.
and I follow them. So to me, that's
You're doing a great
work.
job.
That's employment. I'm doing exactly what I'm supposed to be doing, and I'm not getting paid for it. So actually.
And do you receive any kind of financial support from any organization?
SSI.
And do you know the amount of SSI that you get?
I think it's like 1,000 or something. I'm not sure exactly.
Thank you. Do you have any money in a bank account?
Why? Like, what is this? Why? You want to know how much money I have so you know how much to charge me?
So I'm trying to figure out if you qualify for court-appointed attorney. You asked for an attorney at public expense, and I have to determine that you don't have the financial means to get an attorney. And I have already determined that I am going to appoint an attorney for you. I'm just filling out a piece of paper over here. And one of the questions is, do you have any money in a checking or a savings account?
I don't know right now.
Thank you. So the court is going to appoint an attorney. He or she is going to be reaching out to you in the next week or so. Please watch for that.
Where at? What do you mean they're going to be reaching out to me?
Usually they try to call. I know you don't have a phone, but you do have a mailing address. So it could come to your PO box.
But what do you mean? If I'm going to be in here, how am I going to get that?
So if you're in jail, they'll reach you in the jail.
Oh.
If you're not in jail and you're out on bond, they would potentially mail something to you, but they're going to meet you at the courthouse in Bel Air, and you will appear with your attorney in person. So that will be for pretrial conferences as well as a bond hearing. And we're going to do that on April 16th at 8 a.m.
Where? What is it? I have to meet with the attorney?
you'll go with your attorney to the courthouse here in Bel Air.
On the 16th?
And yes, and we're going to send something to the jail so you have the date and the time and the location in your possession. Okay?
Okay. So I will be here?
So that's what we're about to talk about. Ms. Mistley, is there anything you'd like to weigh in on regarding bonds?
So Ms. Shipley, adamantly maintains her innocence in this matter. She apparently has no paid employment. Obviously, at the top of the list is for her to find somewhere to reside. I don't, to my knowledge, she does not have a prior record, although I don't believe I was sent a CCH on this. She tells me that she will abide by bond conditions. She has no money to post toward a bond.
No, I have money. I just don't know if I do or if I don't. I don't know. I might. I got paid on the 1st. So if I could get to my.
So you do work?
No, I receive SSI.
Oh,
which
okay.
is, I get paid once a month, and it's usually between the 1st and the 3rd, which I did receive.
Okay.
I just don't know if it's still there or not.
There yet?
I know it's there. I know it's there. I just don't know if it's been touched yet.
Is anyone's name on the account other than yours? The account to which it's deposited?
No, but the people that I just don't trust everybody. So to my knowledge, it's still there and I can post something to get out. If my paranoid brain is not, if the people that have access to my account didn't steal anything from it, then I can post something.
So my concern is I did set your bond previously, and it's alleged that you went back to that address that you're not supposed to go to and allegedly had an altercation with the protected person in that case. So we also didn't get a telephone call with an alternate address where you would be receiving mail or staying. And I'm concerned that if we set another bond, that how do I know that you're going to follow through with it this time? So with that being said, on case 25-4668 SM.
Can I say something, Your Honor?
Maybe in just a minute. I am going to remand pending the bond hearing. And on case 25-4696 SM, I'm going to set that bond at 2,500 10% bond so that you're receiving credit for the time that you're serving. So I would ask that you not post that bond so that you remain getting credit for that time that you're serving. Okay. The bond conditions are going to be that you have no contact directly or indirectly with James Frazier at all. You're not permitted to go to 228 East Calhoun Street in Mansalona. You're not to use or possess any weapons of any kind for any reason. Don't display any threatening, intimidating, harassing, or violent behavior toward anyone. Remain respectful of all court employees, service and care providers. That includes law enforcement and corrections staff. And you must follow all terms and conditions of all open cases in Michigan. I don't, so it's alleged that an alcoholic beverage got thrown, but I don't have any information about a positive PBT, so I'm not going to put anything
Right, because it was embarrassingly
on this.
low and this whole thing is super
So what
embarrassing.
I'm going to do is send some
Not yours.
paperwork to you. So if you want to knock on the door and let the officer know you're all set, I'll send some paperwork over to you,
Ma'am, I
okay?
really need to speak with you. I really need to say something.
Okay, you do not want to talk about the facts of the underlying cases at all, because anything you say, and there is a prosecutor who's in the background, they can hear everything you're saying. You do not want to say anything that could be used against you.
This is just about my last bond, when I broke that last bond condition or
Okay, so
whatever.
that's exactly
I'm going to
what
put you
do
in the
not want to
breakout
talk
room.
about.
You need to
The
go with the officer
allegations.
down.
Oh my gosh, they completely booted her. Like they're like they just cut her off. They knew if they let her keep talking, she was just going to keep justifying it and justifying it. Well, no, I'm not going to say anything to get myself in trouble. I just want to talk about the last time I didn't show up. No, that's what you don't want to talk about.
Good morning. Can you hear us, sir?
Yes, I can.
And what is your full name, please?
Nicholas Joseph Samara.
Thank you, Mr. Samara. We are live on the record in case 25-2673FY. You are appearing by Zoom from the Leelanau County Jail this morning. Also appearing by Zoom is Mr. Chamberlain from the prosecutor's office in Leelanau County. And we also have attorney Mr. Lee. She's a defense attorney here to assist you with the arraignment process. What I'd like to do is open a
I
private
do have an
breakout room.
attorney.
You did retain counsel? I haven't seen where he or she filed an appearance.
I also haven't seen that. I'm okay. I'm sorry. Yeah, I don't know. I got a hold of him today, so I'm not sure what exactly happened. Maybe he was busy.
Well, did you speak with him today?
I personally did not. I had my parents do that.
And he was going to appear for this.
I'm sorry. This is kind of hard to explain. I called him late last night, and left a message at his office. I didn't know he was going to have to be here today, or if he called into my lawyer.
Mr. Chamberlain, you're not aware of any?
No. Mr. Samara, what is the attorney's name?
James Sherbin from Newman Law Group.
I haven't received anything as yet. There's no appearance, so you can still get the assistance of the court-appointed counsel just for the purpose of this hearing, and then that other attorney can proceed onwards.
Okay.
Okay, so I'd like to open a private breakout room for you to be able to speak with Ms. Mistley. Are you comfortable going in a breakout room with her?
Yeah.
Okay, very good. So let me do this and I'll speak with you when you return.
Okay.
He's got his muted, but Mr. Chamberlain, with this case, I set bond on a misdemeanor DV. Is that rolled into these new charges?
We amended, okay. So obviously you can do the no contact and bond on an uncharged misdemeanor. During that uncharged misdemeanor, we then charged yesterday with the felony. So it's essentially an amended complaint. That's kind of how I would look at it.
Okay.
And it is rolled in with those, but there will also be new charges. Plus there's the bond motion to for bond violation.
Okay, thank you for that.
Of course.
Welcome back. We're on the record again in case 25-2673FY. Ms. Mistley, did you have an opportunity to speak with Mr. Sumera about these charges?
I did, and we will waive a formal reading of the felony complaint and her pleas of not guilty. And he will be retaining counsel. I'd also like to be heard on briefly in relation to the bond issue. Thank you.
Okay, thank you for that. Just as you were advised, I do want to remind you, Mr. Sumera, you have the right to remain silent. Anything you say orally or in writing may be used against you in court. You have the right to a trial. You have the right to the assistance of an attorney and to have that attorney present for all questioning and any subsequent court proceedings. If you find that you cannot afford an attorney, the court may appoint one to you at partial public expense. With that being said, we are going to have to schedule a probable cause conference, and you have the right to a preliminary examination. I do not have the dates and times available, so I will,
Your Honor,
I will get.
I can tell you when it's likely to be if you would like.
That would be fantastic. Thank you, Mr. Chamberlain.
Probable cause conference will most likely be Wednesday, April 16th at 8:30 a.m. with the preliminary examination Wednesday, the 23rd at 11 a.m. Those are our normal times for those.
So 11 a.m. and then the PCC, did you say 9:30?
8:30.
Oh, 8:30. Okay.
Yep,
Thank you
on the
for that.
16th. You're welcome.
I appreciate that. All right. With that being said, and let's see, as far as the alleged bond violation arraignment, Ms. Mistley, I'm so sorry. What was Mr. Sumera's?
Sure. So we'll be entering a not guilty plea to that request a hearing with his counsel present. I think the court, before deciding about a remand or not, should be aware that there is a pending divorce case. There is much of the back and forth and that we often see in divorce cases, allegations being made that are coming from one point of view and may not actually be 100% accurate. We, from what I understand, Mr. Sumera has a limited prior criminal history, no prior felony convictions. He does have a couple of OWIs from years and years ago, one when he was 17 and another when he was 23 years of age. He's 40, just shy of his 41st birthday now. He is a licensed construction contractor. He's been self-employed with employees for some 17 years. He currently has 2 big jobs underway. Both of them, actually, he's doing some work directly for Pella, the window replacement company. He's had already made some arrangements with his parents, I believe it is, who would be driving up from downstate to assist with some of the child-related issues that have turned into more of an issue than they should have. I believe that we have no need to be concerned about Mr. Sumera failing to appear for any hearings in this matter. He is not a flight risk, and he has assured me that there will be no contact with the estranged wife once this child parenting time issue is resolved. Thank you.
Thank you for that. Okay, Mr. Chamberlain, for the people, is there anything you'd like to add?
Thank you, Your Honor. Your Honor, first of all, I'd like to address some of the bond conditions prior to explaining my opinion on what should occur. First off, there is substance use that is apparent. This stems from originally a civil standby, essentially, for parenting time. At that time, law enforcement, the two that were there, both said that they could smell the odor of intoxicants. He refused a PBT and refused a PBT at the jail. Following that, he was released on the 29th of March. Yesterday, I spoke with the victim while she was in my office. Her phone was texting off the hook. He called her 3 times. It was all from him. As part of that, he was arrested for bond violation. At the time, law enforcement did another operating while intoxicated investigation. They determined that he was under the influence. He refused PBT, refused chemical rights test. A blood draw occurred yesterday. There is a high chance that that will be charged as an OWI third. And then he was also found with cocaine on his person in the jail and a rolled up dollar bill.
Well, there it is. He only used $1. Aren't they supposed to use hundreds for that?
So I believe that as for bond conditions on substance use, he needs to be doing 2 to 3 times daily PBTs and 2 times a week drug testing. As for risk to the victims, she did present yesterday, which will again be provided to the defendant at a later time through discovery, that he texted her at least 30 times. I only recall seeing one of hers texting back. Those are laid out in the bond violation motion. I do think that there is a risk to the victim. I think that there's a risk to him complying with court orders as well. As far as likelihood of obstruction, in that he did ask those text messages, according to the bond motion, he did ask her to not press charges. I believe that if he's released, he needs to be on a tether. He needs to not be permitted to, frankly, I don't think he should be permitted to see the children, because part of the court order was that he be allowed to see the children at 4 o'clock yesterday, and instead told her that he was going to pick up the children at 1 o'clock in violation of the court order. I feel that that there needs to be no contact with the children until as such can be resolved through something with his attorney later on due to these issues. I believe that his bond should be $25,000 cash in the current case. However, I think he should be remanded until the bond violation hearing can be held. The bond motion did provide the original bond sheet, and it did provide the text messages, and I think it also had the probable cause statement for the arrest. I'm not sure on the last one, which all support the bond violation motions, or excuse me, the bond violations. Thank you.
So a brief response, if I could. I think that in this situation, requesting a $25,000 cash bond is outrageous, as is the request that my client have no contact with his children. There are no allegations in here of any harm to the children, emotional or otherwise. I've only had a brief moment to review the single-spaced texts that were attached to a 4-page bond motion, but I did note that there's no text in here from 10 p.m. That says anything about Mr. Samara wanting her to drop this or not follow through with the case. So I'm certainly not suggesting that Mr. Chamberlain is misleading the court. I'm just saying that the documents that were sent to me, either I'm overlooking it or there's nothing in here from 10 p.m. It goes from 9:30 p.m. that only has to do with children's clothes, and then it goes to 2 a.m. And that is a text apparently from the alleged victim to Mr. Samara.
I apologize. Sorry for interrupting.
So again, there is a pending, very unpleasant divorce case. I think the court needs to take that into consideration and weigh the emotions and credibility of those who are making some of these allegations. And I would ask the court to set a reasonable 10% bond. Thank you.
Your Honor, may I respond, please?
Yes, Mr. Chamberlain.
Thank you. On page 1 of when the text started, about 3/5 of the way down through the largest text, the line that this starts on is boys, and it says, if you could talk to the police and have them not press charges. That is from Mr. Samara. Additionally, this is attempted interference with or custodial interference, which is parental kidnapping. According to other texts that were produced that again will be provided in discovery, essentially he says he's not going to give the children to him unless police come and are involved, which I believe covers that particular aspect. The Miss Mistley said one other thing which I forgot.
Okay, so I do see Mr. Chamberlain in that lengthy text. I thought that says 9:10 p.m., so I didn't read every word in there, but I do see, and we'll confirm for the court that is what is allegedly information that was sent by Mr. Samara. I don't know the date or dates of these texts because it does not appear on the 2 pages I was sent.
It didn't scan well. You're right. It's not there. It didn't scan well.
Yeah, can you tell us what that date of those texts were?
Yes, it was the 29th, Saturday the 29th of March.
And it's my understanding that despite Mr. Samara's frequent attempts to get the parenting time arranged, he was being stonewalled at every opportunity, including at the 1:59 a.m. Text from his estranged wife to him. Quote, I know we need to figure some things out, but I'm not ready to discuss this. I'll let you know when I am. Well, he is a father who does still have parental rights, and I think that's part of the problem.
With that, however, there is already parental visitation in place in a court order, and that is sufficient. So as far as parental rights, however, I would again like to point out this is 2 felonies. In my bond motion, I did state that, let me pull it up really quick. Apologize, I just closed it. That there are other crimes that are currently being investigated. This is part 14, intimidated the witness, harassed and stalked the victim under ag stalking, used a cell phone to commit a crime. And also now that I hadn't seen his prior record, there's a OWI complaint that will be coming down with 2 priors. That's an OWI third. So while on bond, there is information to at least support that 4 additional felonies have occurred. For those reasons, I think that my request of $25,000 cash, GPS, PBTs, remand pending the hearing, and 2 times a week drug screens, in addition to all other no contact and things of that nature, is appropriate, Your Honor. Thank you.
Thank you. Ms. Mistley, is there anything else?
Well, regardless of what may or may not be coming down the road, whether it's the existing charges or any future charges, of course, Mr. Samara is presumed innocent. And the co-parents attempt to interfere with Mr. Samara's parental rights and parenting time rights, I think needs to be noted by the court. Thank you.
Thank you. All right. So I do have a note here about the bond violation. District Court Judge would like you to be remanded pending the bond violation hearing. So there's no way around that at this point. So
May I
with
ask
that being
which judge that is, Your Honor?
that is Judge Stepka.
Thank you.
You're welcome. There was a request for a bench warrant with a remand, no bond, pending the bond hearing. So with that being said, I'm going to set this bond at $50,000, 10%, which not posting it right now, Mr. Sumera, so that you continue to receive credit while you're sitting in jail is my personal recommendation to you, okay? If you post that $5,000 right now, you will lose any credit for the time that you're sitting. In addition to that, I'm going to ask that you not consume or possess any alcohol, no illegal drugs, no minor mood altering substances, no marijuana, no non-prescribed medications, which I'd already asked you once before on March 29th. You're going to be required to submit to 3 times daily, as well as discretionary PBTs. As I advised you before, if an officer asks you to provide a sample, you cannot say no, you must perform. You're also going to be required to submit to discretionary and a benchmark urine screen, followed by 2 times per week thereafter.
And it sounds like all of this is just a repeat of what he's already been asked to do by the courts.
You're not to enter any bars or casinos or places that serve alcohol by the glass. You're not to have any contact directly or indirectly with Amy. You need to stay 500 yards or more away from her place of work, her residence, any place she's known to be. You're not to use or possess any weapon of any kind for any reason. You're not to display any threatening, intimidating, harassing, or violent behavior toward anyone. Be respectful of all court employees, service, and care providers. That includes law enforcement and corrections staff. You're not to operate a motor vehicle without valid license, registration, and insurance, nor where there's a presence of any alcohol, illegal substances, or controlled substances. You must follow all terms and conditions of the parental visitation order. You must employ third-party child exchange and communication regarding child care purposes. I'm also going to order a GPS tether with home arrest. You will be able to leave for work, medical, and court purposes. Do you have any questions right now?
No, Your Honor.
Okay, thank you for participating. I'll send this paperwork over in just a little while.
And Your Honor, if I could just have another brief breakout. I mean, I'm done with the court, but just so I can explain that why he does not want to post the bond more thoroughly for him.
Thank you for doing that, Ms. Mistley.
Okay,
I do
thank you.
appreciate that.
Thank you.
Thank you,
Have a good
Mr.
day.
Chamberlain. You as well.
Thank you, Ms. Mistley.
Well, that was a wild ride. We had Michigan, Kansas, Florida, and then some more Michigan. And the kitty toy, it went from red to green. So I think that means that it is ready to illuminate. So we're gonna see here. It's vibrating. What's it doing here? Oh, I gotta get some range on here. Hold up. Okay, so I'm trying. Okay. Hold on, I need the instructions again. Okay, So I must be at M1, which is the farthest, I think. Or hold up, I gotta open this up here. They're at it. They're after it. They're on it. They want it. They want it. So press the button. First is the M1 blue light area. But that doesn't. Okay. M2 is purple light and M3 is yellow light, but blue, purple. Oh, yellow's just in the middle. Blue is, I guess, the most projection. Perhaps. I don't know. Let's find it. Let's see. Earl is already wanting this. Like, all right, come on, buddy. Let's see if. Okay, come on. Well, until let me put it up here. Maybe that'll help. It won't. The range is. Let's push it again. Let's give purple range. No, that's way close. Okay, no. Yellow range. Oh, that goes out. That goes out a ways. I think yellow's going to be the keeper. Quite possibly. Oh, there goes Billy. Billy's after it now. All right, now I got to get out of the way here. I think we're going to like this. I think we're going to like this a lot. Yeah. Ava's got my bed all messed up. She's sleeping on that blanket while she's healing. She's healing really well, though. Look at Earl's stance. Oh my gosh. Thank you so much. Look at how happy they are. This is amazing. I love it. I love it so much. Ooh, Billy's going to get it. Oh my gosh. You have just made yourself some very happy kitties. Thank you, Grandma Bonnie. I know you said that it was a present for Billy, but honestly, it's Earl and Ava's favorite thing ever. It's Ava's favorite game. Ava loves chasing the laser pointer. And I bet if she wasn't in so much pain, she probably would be. It's on the tip of your nose, Ava. It's on your nose. What you gonna do about it, girl? What you gonna do about it? It's on that cute little nose of yours. It keeps scanning your face. Your pretty little face. Yeah. Everybody loves an Ava face. You go potty. You go outside. Okay, guys. I have to take Ava out. Thank you guys for coming and hanging out with me tonight. This is so much fun. I'm coming, baby. I gotta say goodbye to everybody. I know. Look at that face. Look at that face, everybody. She says, Mama, hurry up. I got pee. All right, honey, I'm coming. Thank you guys so much for coming out and hanging out with me. I love every single one of you. Be safe, be well, sleep sweet, and much love.